Good afternoon, everyone, and welcome to the third in the Garden Court webinar series on COVID-related topics and issues. And today we are delighted to present and bring to you a webinar entitled Domestic Violence in a Time of COVID, Safe Spaces in Lockdown. My name is Allison Munroe. I'm a member of the Garden Court family team and I will be chairing today. And I'm delighted and indeed honoured that we've got a fantastic panel to deal with questions in due course, but to present to you from varying angles and various topics, issues arising out of that very topic, domestic violence in a time of COVID and what has been going on during the pandemic. We have, if I may, just by way of introduction, very briefly, we're going to start with Kirsty Richards. Now, Kirsty is a practice, in her practice, she has tremendous experience of domestic violence matters. And in particular, she looks around issues in COVID and issues of maintaining confidentiality during proceedings. After Kirsty, we will have, and I'm particularly pleased to be able to say and privileged to be able to say, we're going to have two very brave women, Rachel and Grace, who are going to be speaking about their own very personal and lived experiences as survivors, and I use the word survivors rather than victims of domestic abuse during COVID. And as I said, we're incredibly privileged to have those two women here today who will be giving very personal and heartfelt, I'm sure, experiences and testimony. Then we have two members of the Garden Court family team. Luke McLean will be speaking on domestic violence bill. Will it make a difference? Luke is one of the newer members of Chambers, but is already establishing a great family practice representing clients both in public and private law matters. And before commencing his practice here at Garden Court, Luke in fact worked for a local authority, so he has experience, as it were, on the other side, and worked on the independent inquiry into child sexual abuse. And finally, last but by no means least, James Holmes will be presenting a view from the bar's practical problems, challenges, and the realities for practitioners that they have faced, securing justice for survivors. James is one of the more senior members of the family team and has a wide-ranging practice that encompasses all aspects of children's law. In particular, James has an interest in public law proceedings, care, supervision and adoption, and regularly appears in the High Court on behalf of children, parents and guardians, but also of local authorities. So those are our wonderful speakers. If you look into the chat, all the housekeeping matters are set out there in the instructions for the meeting, so I won't repeat them now. The meeting is being recorded. There will be an opportunity at the end of all our speakers for a Q&A session, but please feel free to put questions into the chat. I'll be monitoring that as we go along, so I'll be able to direct any questions that may be worth answering there and then rather than waiting to the end for the Q&A. So without any further ado, I'll move straight on then to our first speaker, Kirsty.
Thank you, Alison. Good evening, everyone. Thank you for joining. So for those of you that don't know me, I'm Kirsty Richards and I'm Director and Head of Family at National Legal Service, NLS. So NLS began its journey in March 2018 with just 20 fee earners and one office in the City of London. And if we fast forward to present day, we've grown rapidly now to 20 offices nationwide and nearly 100 fee earners. The Legal Aid Agency has informed us that we're actually the largest legal aid provider for FLA matters, so with non-molestation occupation orders. And so it's fair to say that every fee earner at NLS has a real commitment to domestic abuse. And we're working tirelessly, as everyone is in this practice, to help get legal protection for as many victims of domestic abuse as possible. And we'll hear later from 2 clients of NLS sharing their story, for which we're very grateful. For those of you that like some stats, if we look at the period when lockdown struck from March 2020 to the end of December 2020, NLS stats this is, NLS assisted 2,878 victims or survivors of domestic abuse, and that's for standalone Family Law Act matters only, so that doesn't include our other injunctive work or emergency matters. And in 2021 so far, NLS fee earners have helped nearly 1,500 clients, so 1,476, and again freestanding FLA applications. So that's a total of 4,354 for those of you that don't like mental arithmetic like me. So that's the number of clients that we've assisted during lockdown with domestic abuse. Not an insignificant number. We all have seen the other stats as to how much of a staggering increase there's been in calls to domestic abuse helplines across the country. So what would I say about my experience of domestic abuse during the COVID pandemic? Well, back in, well, it seems a long time ago, 11th of March 2020, NLS actually started a trial of numerous fee earners working from home. And before lockdown was officially announced, all our teams are already working from home, continuing to speak to victims of domestic abuse, preparing urgent applications for protection from the family court. And as at that time, there were many practical issues in and around how applications were being dealt with courts all over the country taking a different approach on how they would process applications, how they would hear the applications. And so NLS tried to ensure and did ensure very quickly in a matter of 2 days that each and every fee earning team had a secure conference line that could be offered to the courts for telephone hearings. Now, some courts welcomed that assistance, but others did not, is all I should say. Then came the plethora of guidance from the president of the family division, which obviously helped outline how we as practitioners and judiciary and court staff should all come together to ensure the wheels of justice kept turning. That advice was welcomed by everyone. And then everyone was adapting to a very strange work setup and the notion of dealing with court hearings at home, which we're still doing now, 14 months later. Everyone was under so much pressure at that time, and yet despite the issues around actually getting applications issued and heard, fee earners were more determined than ever to get non-molestation orders applied for, as they too were seeing such horrifying numbers of clients coming forward and seeking help for domestic abuse. I'm sure that actually many practitioners and barristers that are joining and other professionals will have similar stories of being told that your client's application has been issued and that you'll be called to join a hearing, only to be told some hours later, and having chased a lot, that the matter was dealt with without you having even been heard from. Or worse more, the ex parte application had been refused and the matter put on notice. Now I speak just from the NLS experience. So we experienced instances of clients having been informed that due to technical or other issues at the very beginning of lockdown, that their legal representative had not been called and would not be joining the hearing. Submissions were therefore not made on their behalf as to urgency, merits of applications, and the judge had continued with the hearing and made a decision that the application was suitable for on notice. Given the number of clients that we deal with at NLS, we did see this happen quite a lot at the beginning. What happened in those instances at the beginning particularly was that those clients were actually telling us they were so terrified about their application being put on notice that they wanted to withdraw their application immediately. So that's a complete nightmare situation for the client, obviously, but also for the fee earner that's taken the instructions, has assessed that in fact what had been put to the court was urgent and the facts did warrant an ex parte application, and so advice had been dispensed to the client accordingly. only to then have the judicial discretion exercised in a way in which, on our instructions at least, put the client at risk of significant harm because no order had in fact been made ex parte. Now, depending on the case, obviously there are different options as to how you could deal with that scenario as and when it was happening. But that was just to highlight some of the issues we had, very real issues we had in and around the technical difficulties at the height of lockdown 1.0. Now we're in 3. But what does that type of experience say to those brave survivors of domestic abuse as well? This is a court system that we're very familiar with as professionals, but for the clients it's often their first time or first time coming to court for domestic abuse matters. What we know from our experience from our clients is that they're terrified that they will suffer domestic abuse unless orders are put in place at the earliest opportunity so that they can have that protection. And so they're genuinely fearing of reprisals if the respondent finds out about their application, and hence being put on notice when they've given a witness statement full of some of the most intimate and personal details. They were just absolutely terrified as to what was happening. And of course, it was very difficult to advise the clients as well as to whether and how their application would be dealt with, because the courts were all struggling to deal with the pandemic and the urgent shift that is needed to go to completely online. So for many survivors, it can be said that it's actually been quite a harmful experience in the beginning, which actually further compounded some of the issues around their feelings of self-worth and self-confidence, which has already been chipped away at or completely depleted in some instances by the abuse they'd suffered. And that was the abuse they were seeking protection from in our family courts. So when situations like that happened, obviously as a fee earning solicitor, I'd often have to take my lawyer hat off and give them a friendly ear, trying to reassure them that no findings have been made as to any of the facts that have been alleged. The judge hasn't said that he or she is not believing the contents of their statement, and trying to really reassure them in any way possible that they should continue with the process and that we'll guide them as best we can and help to really navigate through the family court system to try and reach the right outcome. Now, some clients obviously did not feel able to do that, such was their fear, but others did continue, and we tried to and help navigate them as best we could. What we saw is that not only were the clients becoming so emotionally drained and quite unsure about the process because it was adapting so much, but fee earners especially were feeling it at the beginning. They were dealing with increasingly large caseloads as domestic abuse cases were spiking, large caseloads, 30 to 40 clients each, all of them needing help, all of them saying they're urgent ex partes, and each one of them just as vulnerable as the next. And of course, much was said about well-being and the impact on the profession as to the working from home environment, but not just that, but the increasingly long working hours, each hour, of course, blurring the line between work and home life. Much welcome guidance and views continue to come from the president of the family division, but in reality, it can be extremely hard to respect your own mental health and well-being when you continue to have new clients contacting you, reporting domestic abuse and needing urgent assistance. I for one, no matter how busy I am, if somebody comes to me asking for help, I just cannot say no. I cannot turn them away. And I'm sure with everyone that's on this webinar will have stories of having to work way beyond midnight, 1, 2, 3 in the morning, just dealing with as many clients as you can, trying to get them all ready. They're all important, all reporting such serious, horrendous domestic abuse. Each one of them mattered. And it was a really difficult time, I think, in the first lockdown, particularly whilst all the processes and procedures were put in place. So aside from issues arising from issuing applications, there have been many occasions as well where we experienced, despite providing telephone numbers to the court, that advocates were just never contacted, as I said earlier. We just weren't invited to join the hearings. And so the client was asked and expected to continue without representation. Again, whether adjournments are actually permitted depended on the decision of the judge dealing with the case. And without their legal representative, that could have quite serious consequences for some of the clients that were just so scared that they were then faced with dealing with a hearing on their own. Afterward, the clients have told us that they've had feelings of anxiety, stress, real distress. And then the legal representative themselves has obviously spent hours trying to manage things in the lead up to the case, trying to prepare that client for what to expect. And none of that happened at all. So very difficult to manage from fee earner's point of view, but as well from the clients. Thankfully, when we come and move forward to June 2021, we're all in full swing with remote hearings. We all forget to mute and unmute, but there we are. We're a lot more experienced with it. And in the main, many courts are now using either CVP, Teams, or Zoom on occasion, or telephone hearings. And the links are being sent to parties and clients well in advance. So it's been really good to see that progress over the lockdowns. That definitely is working a lot better than it did at the beginning. But are those links sent through with enough notice? Again, another possible trigger for clients can be that they're waiting for a court hearing and a link. And the more they wait, the more anxious they get. So we can sometimes get 10, 15, 20 emails asking for a link that we ourselves haven't got, but we're trying to say to them not to worry. But it can make it difficult to manage the client's expectations. And it just makes you think, what image does that give to the clients of the family court, the place where they're coming to ask for protection and help? I think there's always more we can do. So of course, when we're actually in the hearing itself, we're now all very familiar with the warnings given at the beginning around the consequences of not adhering to the rules, about not recording the hearings ourselves, being in a quiet place where you can't be overheard. And the number of times that I've been given those warnings, and I'm sure you've had it as well, you find yourself wondering, just how do we really know that no one else is in the room with that person, that they truly cannot be overheard? There was even stories put out on Twitter where somebody was arrested during the hearing because they could tell by the background they were actually in the same room as the victim. So it's been very difficult, I think, to establish and ensure privacy during these proceedings as well during the pandemic. The warnings are given, but there's really no checks done. So I think that needs to be looked at and continually thought on how we can improve, particularly if remote hearings are going to remain, which they appear to be. So I think one of the biggest worries as well has to be whether vulnerable clients are truly on their own for hearings, or whether their abuser is present, as I just discussed. If not the abuser, there could be some other family members or friends, all there to put some pressure on them. You have probably all by now had at least one case where you think someone keeps looking off screen, so you know somebody must be there. Judge doesn't necessarily pick it up, you don't necessarily know, so it's not raised with the judge. But maybe we ought to do that to protect the clients a bit more. So there have been polls and surveys circulated recently asking for the views of us all on remote hearings in the family court, if they should remain, if so, in what circumstances. And if we just think about Family Law Act applications for now, Some victims and survivors can truly be too terrified to even leave the house for fear of being followed, stalked, abused, that they've actually welcomed the ability to join and participate in hearings from their own home. It, of course, runs a risk of just not really knowing who's present in the client's home. But there's certainly been the positive feedback that actually that does relieve some pressure. Certainly if the respondent has already fled and you've got some confidence there that they're on their own or with children. Because of course childcare has been a big issue for many clients and many survivors. So should participants at hearings be asked to reverse their cameras or asked to show around the room before a hearing begins to make some effort in establishing it if they're on their own? I don't know, but it doesn't even if you did that, it doesn't mean someone stepped out of the room having heard the warning and then they rejoin to put the pressure on. But if we have the discussions, maybe some other ideas can be put forward and we can make this better for the clients. Because privacy in the family court, of course, is so important for many reasons. But I raise it here for the safety considerations and the real lack of certainty any of us have as to who or who is not listening that shouldn't be. So we need to keep sharing our experiences so that we can learn from them and make sure that the family court is accessible and is a safe place to attend remotely and in person. And you are going to hear very shortly from two very brave and amazing women during this conference. And in fact, one of them is speaking straight after me. They're both clients of NLS and they've both experienced a family court, completely different applications, but they've had their applications during COVID-19 and they're now willing to share their accounts with us so that we can all learn their experiences. So thank you from me to Grace and Rachel, and I'll end my part of the session. Thank you.
Thank you very much, Kirsty. That was really excellent and very instructive and very timely information. Thank you so much. Rachel, if you're ready, please begin. We are, as I said, very delighted and privileged that you're going to share some thoughts with us. So please, at your own pace, Rachel. Thank you.
Okay, I'd like to introduce myself. My name's Rachel. Before I begin, I just want to explain I've got complex post-traumatic, so bear with me if I go quiet or funny, as it's really hard to talk about. I've been a victim of horrendous abuse. It's not just normal abuse, it's horrendous. Sorry. It started at Engine Lane. The abuse I dealt with was for nearly 3 years before an officer even came out. The abuse was every day, every minute of the day, even at night. Sorry. He'd wake me up my sleep. He wouldn't even let me sleep. I've got 2 disabled children that I look after, and they're hard work to start with, let alone dealing with what I had to deal with. I'm not going to talk about the abuse, but I'll talk about how I got out. The only way I got out was from a police officer attending. He come out. I was covered in bruises. I was unable to speak. They found me on the bed, no clothes. I didn't even know what had happened to me because the abuse was that bad. My body started to shut down. Sorry. So I got out of there. The police officer had luckily just had domestic abuse training. And because of that, he knew what was going on. I couldn't tell them anything. I couldn't speak. The first thing they thought was I was on drugs, which is what the domestic abuser had always wanted people to think. Next, I find myself in a hospital, which he'd always threatened me would happen. I'm going to do it until no one believes you, and I'm going to get you sectioned and our child took away. that was always on my mind. I ended up in hospital in COVID, which was very confusing as well. He was withholding medical, ambulances, police. He was taking my mobile phone. He stopped my family talking to me. It was any help that I actually needed was gone. And I'm going back a little bit as well because I forgot to say it happened in lockdown. So I was actually locked in with this person. The only break we had was when he went to work. He took over my house. He took my car. I had no car. I used to walk the kids to school. He took every bit of money I had. All my kids' bank accounts, they were gone. He took all my friends. He was going to my family and making them think I had postnatal depression. It was just awful. I ended up in Good Hope, and the officer didn't need my side. He was worried that he was going to come in and get me. He did have to leave me in the end because he was told he had to leave. He gave me a code name to ring him back so I could get in contact with him, as he was worried I wouldn't speak. I was unresponsive. Everyone was talking for me. I could hear what was going on. I could hear the conversations that my family were having that were not even right. It was awful, but it was the most rest I actually had. I was worried about where my children were. I knew he'd be on the phone to my mum trying to get my child, and he was. I got out of there, and my family actually got another abusive ex to pick me up. I was hanging on the rails. No medical staff or no one was listening to me. That's the last person I'd want to pick me up. And then I got home, and I spent 5 days at my mum's. I couldn't speak. The police kept coming out every night, not understanding why I couldn't speak. That was hard alone. And then thinking that you've got out and that you're free, that was nowhere near where it was. It was just the beginning of how the police, I feel, knew what went on. They took my phones. They must have gone through them. They must have known the abuse that was on there. I was hiding my phone from the abuser the whole time. I was risking my life getting videos of what he was doing. One handset had 7,000 texts and voicemails. I couldn't even open the voice notes. I'd pass out. I just don't know how I was left like that by a police force. The only person that helped me, and that I've got my family and kids with me, is my solicitor, Jazz. He's done more than people that are supposed to keep you safe. The police didn't really protect me. They just said, ring this line. I don't know. I think my mum rang that line. I was unresponsive for 5 days. And then expected my mum to talk about what happened when I've never even told anyone by Jazz really what has happened because I couldn't. It's the last thing I'd want anyone to know, let alone my mum. And it was that shocking. Even now, I don't think the police force even believe how bad it even is. So then I got put through to Jazz. I think at the start he must have thought, wow, I weren't making sense very good. I was in shock. And then to find out I had to relive it all when I was only just come round to talking. I had to go through that with him, who was great. He was really helpful. That was hard going through that. Some things even your body has forgot. And we managed to write. It was long, and that isn't even all of it. I mean, writing all of what had happened down would be days. He helped me through it all. He knew to get all the orders that were needed, not just the emergency non-mole. He did the prohibited steps, the contact order. He knew what he needed to do. He knew how much danger I was in. And that was the gratefulest thing, is I didn't really have to do much because Jazz did it all. But, you know, you had to be honest with some things that these people can still do, which I find shocking. They shouldn't be allowed to see their children. I mean, I know some people, you get low-end domestic abuse. This person was hitting me while I was pregnant. He was stamping on my chest. He let me pass out. She was born, and I was just left with her. And then he started hitting me again when she was born, abusing her, kicking her up out of sleep. It was awful. Jazz did all the work, getting all the non-mole. I can't really say I had any problems with the family side because Jazz knew exactly what he was doing, made sure it was all done. It weren't easy for him. I think the fight you have to give up with these people in court is just horrible. I mean, to even hear him in the phone calls say everything in his statements that he'd done to me, he had said I'd done to him. It was awful. The non-mole, that is absolutely no protection to anyone. It was made him worse. The abuse was horrendous from that non-mole. He got issued the non-mole, and the person that issued the non-mole rang me up within 2 minutes and said, he's come in to your house. I've just issued it in, and I'm really worried for your safety. He's actually come in. He told the officer he was going to burn it. He doesn't care, and that he's come in, and he did. That was just the start of it. I lost count of how many times he's broke it. And he's, as far as I'm concerned, not been dealt with properly. The first breach, they said he broke it nicely. There was that many breaks that this person was doing. He was doing thousands of social media posts, just breaking it left, right and centre. Jazz was working flat out along with another colleague and a few other people. That it was just, he was sliding through everything. He wasn't putting my name on. There were breaks, but I don't know why he's not got charged for them. It's just, I mean, even breaks to the point where the solicitors were fighting with the police. There were breaks. And it just didn't stop. It was every single second of the day. I couldn't go out. I couldn't go to the shops. People were threatening me. My children were collapsing on bike rides. The police were at my house near enough every single day, trying to deal with them. And one of my children, they're disabled, they were passing out. It was not on what we had to go through. I don't know if I'm going a bit off here with the subject, sorry. It's just been Jazz and the solicitors fighting the whole time, all the way to the end, constantly with him. We'd have family court, and he'd even have the cheek to privately email the solicitors, egging them on, saying he couldn't wait, it was the final trial. It wasn't the final trial. It was just awful. Had to go through CAS meetings and try and fight with the lies that he was telling. There was one episode that got me in his statement where he said I'd wake him up out of his sleep, and it was what he'd done to me. It was just me. I've spent since 2020 last year, even up to now, constantly fighting this person.
And Rachel, it's Alison here. And so where are things at the moment in terms of the proceedings and the process? As you said,
the family court one. So we got the non-mole. He's been charged with that. Community service, a fine, and courses to make him better and learn from his mistakes. That he still broke it after then. He got given bail. He come out and broke it again. He broke it again, and he pleaded not guilty. They're very clever, these people. It's unheard of, apparently. He had the phone, they took the handset, which he lied about. He said he'd lost it. He took my phone, my spare phone. It was all linked to the iCloud. He knew everything I was doing. I had no clue. He said he'd lost the phone, and when they arrested him on another non-mile break, it was hid down his pants.
And Rachel, of course, you mentioned that going through all this trauma of the actual abuse, and then the process with authorities, some of whom are still quite reluctant to believe women, in particular women, who have endured this. This all happened during the pandemic, of course. And I think it was the National Centre for Domestic Violence that coined the phrase last year as part of their campaign that abusers always work from home. That aspect of it, being trapped, as it were, with you and your children being trapped in a home with your abuser. At the time, how was that experience for you? And in terms of, and at the time, were there any mechanisms or any resources that were available to you in particular in that point?
He took my phone. When he went out, he'd lock me in the house. We couldn't even get out. There was times when I don't even know what I was taking. He was feeding us. I couldn't get out of the bed. My children were asleep. My dogs were asleep. I didn't even know what time of the day it was. I still don't even understand that now. There was a time when I tried to get out, and I remember he fell asleep. And I said, we need to go. And the back door was open. I got them all. And I managed to get to the bottom of the stairs when he woke up. And I said, come on, we need to go. And then he stood there and went, if you go out the front door, the police are there. So I said, come on, listen to me. We need to go out, we'll go out the back. And he said, you go out the back, this is to the children. And social services will get your mum. So do you want to go out the front or do you want to go out the back? And my son caved in and said, please, I don't want you to go anywhere. I had to go back up. Because my son was getting upset, I would have got out.
I think
Rachel,
Yeah, that really does very graphically explain and illustrate being trapped, and how many women found themselves in that position, that they literally were imprisoned during the pandemic with abusers. Rachel, I just want to thank you so much for giving us, I know how difficult it has been, and you've only been speaking for, 15 minutes or so.
Yeah, I mean, I've got pages and pages to go, even what has even happened, but
yeah.
That's just the start of what's actually gone on. And the only people that have helped me is Jazz and his team, because I'm fighting a police force to charge this person now. If Jazz wouldn't have done what he did, I don't know where I'd be right now. He may have the children. It's just awful, the amount of work that has to be done, and you're working with guidelines that are not helpful.
Yeah.
I mean, I didn't even know, because he broke it that much, that if in the 7 days, if he breaks it as many times as he wants, it goes down as one. And he knew that, so he harassed me terribly for 7 days, because he knows he's only going to get one break.
Well, it's really reassuring to know that you had such a wonderful solicitor, such a wonderful lawyer who was advocating in every sense of the word on your behalf. To get
I mean, I even wanted to drop in quickly before I went. I did end up in a section unit. I had to get myself out of there, ringing Jazz. I didn't need a solicitor because I wasn't mental. That was the most scarring thing I've ever been through. And even then, he's been with me every step of the way. He told me all the rules. I had no idea I even lost my parental rights in there. And he gave me the strength to get up. I nearly gave up in there to get out. And I got out. Well, it's been horrendous.
All I can say is that you've shown immense strength of will, and just strength full stop, coming online today and speaking to complete strangers to share your lived experience. I know there will be some more questions and answers at the end, but for now, just leaves me to say thank you so much, Rachel. I hope
no problem.
It hasn't been too bad. That wasn't too horrendous for you sharing. You spoke.
No, I mean, I've still got him with me now at social services level. It's just he's still here now, and this is how much damage that these people caused from 2020 last year, and we're still trying to fight him away now. And he's in remand, and we're still fighting him away. And he's not gone. They're ruining lives.
Absolutely. Absolutely. Thank you very much, Rachel, for now. There will be, as I said, there'll be Q&A at the end, so I'm sure there'll be some more questions for you. Particularly, I suspect people will want to know more about your experience of the police. As you seem to be understandably...
I haven't got into that bit yet.
Yeah.
No problem.
Okay. Well, thank you for now, Rachel.
No problem. Thank you. Thank you for listening.
Absolutely. Thank you so much. We'll now move on to Luke. Rather nicely segues into Luke's presentation about the domestic violence bill and will it make a difference. So Luke, please take it away. Thank you.
Thank you, Alison. Hello, everybody. So thank you to Rachel for talking about her experience. I must say, you're really an inspiration to have gone through that and come out at the other side as a survivor. That shows your strength. So thank you for sharing your story. If you just give me a moment and I'll open this slideshow.
No, thank you.
So what I want to talk about today is the Domestic Abuse Bill, which is now known as the Domestic Abuse Act. And I guess I'll start by outlining some of the statistics in relation to the increase of domestic abuse during COVID. So Refuge recorded an average of 13,162 calls and messages to his National Abuse Helpline every month between April 2020 and February 21. And this is an increase of more than 60% on monthly contacts before the first lockdown. And between April 2020 and February 2020, it logged a total of more than 131,000 such contacts, and 72% of the above are from women. And so I guess this leads in nicely because the domestic abuse bill was passed on 29th of April 2021. And so sort of good timing to introduce some new measures which we would hope would assist victims who are suffering from domestic abuse. And the government say that they're pumping, or the cost of the measures as a result of the Act is going to cost 247 to 300 million per year once fully implemented, which I believe is a big contribution. So I hope that that money does actually create some change for victims. So what are some of the new introductions following the Act, the introduction of the Domestic Abuse Act? Well, we now have a definition of domestic abuse, which we've never had before. And this is codified into law. And those conditions are, you need to be 16 or over, the parties need to be personally connected to each other, and the behaviour needs to be abusive. Abusive is if it consists of any of the following. So physical abuse, sexual abuse, violent or threatening behaviour, controlling or coercive behaviour, which is a new topic that all family practitioners have seen come up over the past few years. Economic abuse, psychological abuse, emotional abuse, or other abuse. And it doesn't matter if this behaviour is a single incident or various incidents. And so what is the definition of personally connected? Well, you need to be married, civil partners, or agree to marry one another, civil partnership agreement. Parties need to either be in an intimate personal relationship or have been in a parental relationship to the same child, or they could be relatives. So sometimes there's cases where you have disputes between family members, such as mother and child or brother and sister. Those are not uncommon. But these examples are very similar to the associated persons provisions, which we all would be familiar with in relation to non-molestation orders and occupation orders. So as you can see on the screen, I've put in star the sort of the definitions that have been duplicated, and which are nearly all of them. The only different ones are cohabitants or former cohabitants, lived in the same household, and parties to the same family proceedings. So they're near enough very similar. So not much change there. And so what are some of the other introductions following this new legislation? Well, a commissioner has been appointed by virtue of Section 4 of the Act. And that commissioner has a list of functions under Section 7. And some of these functions, or one of these functions, is to make recommendations to local authorities and to encourage sort of the best practice and how to respond to domestic abuse. And once you make recommendations to a local authority, that local authority has a duty to cooperate and respond. And so that's, I think, is a strong provision, because they have a duty to cooperate and respond. And they also have a duty to make arrangements for the assessment of the need for accommodation-based support. So that's also a good introduction, because although we do know that victims get some sort of accommodation-based support, it's good that we have it codified into law that it's a duty to at least assess that person's needs for accommodation-based support. And there are other provisions as well, such as protection for victims in terms of prevention of cross-examination. And again, we know this happens now, where the court would not allow a suspected abuser to cross-examine the victim. But again, it's good that we have this codified into law that it's not allowed. But I think the most interesting introduction, in my opinion, is the introduction of the domestic abuse protection notices and domestic abuse protection orders. So what is a domestic abuse protection notice? Well, a senior officer can issue a DAPN if he has or she has reasonable grounds for believing that a person has been abusive towards another person who is age 16 or over, to whom that person is personally connected to, and that officer has reasonable grounds to believe it is necessary to give notice to protect that person from domestic abuse or risk of domestic abuse. And so what this DAPN does is, I guess it could provide essentially similar protection to a non-molestation order. So not to contact a person or not to go within a specified distance from a person's home. And the benefits of a DAPN, in my opinion, is that it's quick. A police officer is obviously the person who issues it. And like that example that Rachel just gave us, where police officers didn't do anything and they just gave her a number to call, I guess now we would hope that they take things into their own hands and issue a DAPN. But essentially what it does is it avoids the delay of going through a criminal investigation to get a restraining order, because to get a restraining order, usually you need to go through a trial, which under these current circumstances, trials have been listed years in advance. So that's no assistance to victims. And it avoids the wait for a non-molestation order. So again, when you apply for a non-molestation order, that can also take some time. Apologies. And yes, so I think it's generally, it gives us some immediate protection. Apologies, I can see on the screen my slideshow twice. If you just give me a moment.
Luke, I can only see it once.
Okay. All right, thank you, James. I'm having problems. I'm having trouble changing my slide. If you just give me a moment. Okay, here we go. Apologies. So yeah, so essentially it gives victims immediate protection, I would hope. So what are the consequences of breaching a DAPN? Well, if you breach a DAPN or an officer has reasonable grounds for believing that a person is in breach of a DAPN, a constable may arrest that person without a warrant. I mean, what I would hope is that rather than may, the constable must, but it is what it is. So it may arrest that person without a warrant, and that person must be held in custody and must be brought before a magistrate's court before the end of the period of 24 hours, beginning with the time of the arrest. And the importance of that is not to just be brought to court for the sake of it, but it leads into what my next slide is, which is the court needs to give consideration as to whether a domestic abuse protection order should be granted. So what is a domestic abuse protection order? Well, it's essentially a DAPN, but rather than a notice, it's an order from the court, not the police. And it prohibits the person from doing things, or it requires a person to do something. And I guess this is basically a non-molestation order. It's basically a non-molestation order. I can't see any difference between this and a non-molestation order. So I guess you may be thinking, well, what are the differences? What's changed? Why is this new act any better than the Family Law Act? Well, I guess one of the benefits is that various persons can apply for a DAPO under Section 28, which again is beneficial because you get cases where police tell the victim, go and get a non-molestation order. or the local authorities say, go and get a normalisation order. But what if I don't know how to get a normalisation order? What if I can't afford one? Which I mean, most victims do get legal aid, but what if I'm scared to apply for one? And these are real concerns. And so I think it's good that more people can apply on behalf of that victim's behalf. And we can see here who can apply. So a chief officer can apply, and persons specified in regulations made by Secretary of State. And I assume that would include people like local authorities or social workers or persons of that nature. And so I think this is a plus. I think this is a plus, and this is something that would assist or will assist victims in the future. Now, DAPOs, they can be made by 5 ways. 1, by making an application, or 2, as I mentioned before, if a DAPN is made, the officer must apply to the court, and they must consider a DAPO. And this needs to be heard no later than 48 hours before a DAPN is given. A DAPO can also be made during family proceedings or after the conclusion of criminal proceedings, and it can also be made in civil proceedings. So that's a plus. So you can get a DAPO in near enough every element of the legal system: family proceedings, criminal proceedings, civil proceedings, and so forth. So why is the fact that more persons can apply on behalf of the victim, why is this essential? And I think the main one is that usually you get victims who are fearful of making this application, or the abuse is so bad that they just don't make it for whatever reason. They just don't make the application. But it will be interesting if you can post in the comments any other reasons you think is important why more people can apply on behalf of the victim. The standard of proof to prove abuse is balance of probabilities, and it needs to be proportionate. So there's no change there. And again, the powers of arrest, if you breach a DAPO, are very similar to consequences if you breach a non-molestation order. So imprisonment for a term not exceeding 12 months, or a fine, or both. If that person's convicted on indictment, then imprisonment for a term not exceeding 5 years, or a fine, or both. Some further pointers. A DAPO can last indefinitely. So I understand there's something called domestic violence protection orders that are in place now. But they have a limit of 28 days, which is useless. What's the point of having an order which only lasts 28 days? And so a plus is that with this new order, it can last indefinitely. And I think with non-molestation orders as well, I certainly haven't seen a non-molestation order that's permanent or indefinite. Usually there's a time limit. So I think that's a plus. And also I've gone on the government website, and what they say is that statutory guidance for how this act is actually going to operate in practice will be coming soon. And because at the moment it's unclear as to how this framework will work alongside the current regime, which is the non-molestation order regime, because they're kind of very similar. But in relation to that point I just made in terms of the similarities between the two, I guess what I can say is that in the year ending December 2020, 36,952 non-molestation orders were made, which is a huge amount. But the government predicts that 55,000 DAPOs will be made per year. And a plus is that victims will not have to pay a fee to apply for one, and legal aid will be available for persons who are applying for one. So I guess this is a plus. And so really, I think all in all, in conclusion, I guess what the Act is trying to do is offer people or victims, immediate protection, and enable, I guess, more parties to apply on their behalf. There are more provisions, but those are the only topics that I've chosen to speak about today. But I guess I came into this presentation thinking it's a good plus. This new act is a good plus. But then I've heard Rachel's story, who says her partner he didn't care about the order, and he just continued and continued. Now I just don't know. In terms of the consequences for breaching an order, they're exactly the same as a non-molestation order. And so I'm not entirely sure how, if this is going to sway people from committing abuse, but there we go. That's where we are. So thank you. I'll move on we can now move on to the next speaker. Thank you.
Thank you so much, Luke. That was really instructive, and I'm sure for a lot of us who haven't delved as deeply into the legislation just yet as you have, a very nice lesson and some revision for us. Thank you so much. So we move on to our final speaker, last but by no means least, James Holmes. And James is going to give us yet another and a very different, I think, perspective on this issue of COVID and domestic violence in a time of COVID. So please, James, in your own time. Thank you.
Good evening. I'll keep this as short as possible because no doubt people have many questions they would like to ask the panel, which they can do so after I've finished speaking. What my topic, or what I was going to talk to you about, is the challenges and realities practitioners have faced securing justice for survivors. And having listened to Rachel's account, what justice can be obtained for survivors is questionable in respect of people listening to orders. But the difficulties I think encountered in COVID from the view of counsel, so a slightly different perspective from Kirsty, is I feel the biggest thing that I've noticed is different. The hardest thing is at the very beginning, we were all working from home, not a problem. It will make it easier, less traveling, etc. And what I think is actually reflected from my view of our role in the court, and as much for the solicitors as well, is supporting clients. The ability, the lack of ability now of the challenges and I think realities now of working in COVID at the moment remotely is having clients at the end of a call that you can't talk to. You look back at what would you do with doing these applications, dealing with clients who are having difficulty, who need a break, who need someone to chat to, who break down because evidence is absolutely traumatic that we deal with. We can't go and take it for the cup of coffee that we would do, or the cup of tea after a hearing, or even if it is just taken to a side room and just having a chat. The reality and the hardest thing I have found is having a client listening to something, judge, and all of us seeing them getting visibly upset, and judge going, Mr. Holmes, we need a break, can you ring your client? Trying to ring your client and wanting to speak to them to make sure they're okay. And the client texts me back, I can't speak, I don't want to speak, and just leave me for a moment, which is not her being rude, but there's no way to provide any sort of support. And all then that happens, we log back in. So there's been no real sort of decompression. We as practitioners, I feel, have this as an issue from our well-being. But I think this is a real problem and a difficulty as anyone who deals with it, deals with our practicing, to decompress your client, to have a chat with your client, try to talk them around, have any sort of reassuring. I know people say the reassuring hug. I know I've had many practitioners say to me, that's sometimes what you would have to put arm around someone's shoulder. You can't do that virtually. And I also feel like the hardest part now, and the reality and the practicality of this, is everything becoming a bit distant, everything possibly becoming real. It was all being on a computer screen or being from the seat of your own home. And actually, Rachel's account, I think, brings back the reality of the job that we do and why we do it. And sometimes actually it becomes a lot harder in the sense of doing it practically on a remote basis. So on a personal level, that's the challenges, I think, and some of the realities that we are doing. And I think something I've heard talk to people about, trying to talk to people, clients, getting them to have a discussion with you, because you don't know if they're alone. Not because they're alone. How are they taking your instructions? Do they have somewhere else to go? Other realities, as you heard Rachel's account, but we've all had account. If you are the victim and become the survivor, you generally leave with nothing. How do you do these remote hearings? You can't turn up to solicitor's office. You can't go and speak with your counsel. It's just a practical minefield in those circumstances. And one thing that is also I have encountered is a delay in everything. It's very easy or easier now to get the first hearing, get the protective order put in place, but getting the matters resolved, dealing with and getting a kind of not some sort of closure, some sort of protection, some stop of the coercive control through proceedings is not being helped during these times. I'm speaking with members of chambers. It's not unknown, 8 months, 9 months delays between hearings, further delays because police don't give information, CAFCAS don't give information, all of that. So it's being compounded by COVID, and COVID is causing those delays. And I feel that is another practical issue. And solutions, what solutions are there? In respect to listing delay, I don't know. But one thing that other practical issue I had at the very beginning, and thinking back, it's something I didn't think about to start with, is you are now in my kitchen. I am talking to you from my kitchen. What about if you're a victim, a survivor, that my house and my home is my own safe space? You leave somewhere to be in your home safe space. And that reality is you are now all seeing my room. But if we are in a court hearing and you are trying to flee and feel safe and complected and wanting to have not that person in your personal space, that is what these hearings are now doing. That is an issue in these hearings. Zoom, you now can't see me. We've got it set up so I can't see you, but you can see me. And the issues with the court system up until now is that is not being possible. That we can't have people not seeing one another. You can't have the special measures you have in a courtroom, the screen, the separate video conference room that you therefore can't be seen. You are seeing the victim and your abuser can see you. But what is happening now, I've been informed, is CVP allows the judge to block individuals seeing one another. So if in domestic abuse cases, and I think there's something we all need to be aware of and should be asking in all cases, is that the abuser is not able to see your client. The victim has that safety that she does not have to look at a screen. I've heard stories of people getting post-it notes and trying to put a post-it note over parts of their screens so they can't see the person they very much fear. That very much causes them problems. And that practical problems there, best evidence of clients. Clients can't give their best evidence when they are staring at a screen with the person who has been abusing them looking straight back at them. How is that effective? How does that work? It has been ineffective, COVID in remote hearings for now, in securing that. Judges got no solutions, save for getting one person to phone in when they're giving evidence, but that's just not acceptable. So I welcome the changes that now have been put in place so the judges can do that. That other practical problems, which especially in the private law stuff that I do compared to the public law, technology, doing hearings properly, clients giving best evidence. Again, most people only have one device. Most people don't have the luxury of having a computer and an iPad or something like to see things. So how we're getting justice at this moment in time, we are doing as best as we can in times that are very, very difficult. But something that I hope will be remedied going forward. I heard Kirsty say clients very much prefer some clients very much prefer the remote hearing so they don't have to leave their homes. I think that is something that should remain, if at all possible. But I also feel that the difficulty is making sure clients don't feel pressurized in either way. Having the fair option, having an option that enables them to go, look, you have these choices. You can go to court, you can go to your solicitor office, or you can stay at home. Because it's the options being there, I think, would be the thing that is the solution going forwards. Is losing one or the other, or being only able to do one, will not help. Because it will work for some people and work not for others. And I think also puts a massive burden upon solicitors, making sure papers are either you send a bundle to that address, or you're going to have to make sure your client has that other device. And so all those things, I think, are issues that we faced, and I faced in particular. And finally, and my final point, and I think Kirsty touched upon it before we go to questions, because I know the time, is burnout of everyone. Solicitors who do the job, working early out, taking the phone calls. I don't envy the people, I don't envy the task of those solicitors, IDVAs, anyone who works on the very front of the coalface, taking those phone calls, waiting for the clients, finding a safe space to make that phone call, having to work until early hours in the morning. You then have counsel doing the same. You have judges, and the system at the moment, as it is, the pressures put on it because of the fact that listing and so forth, it will come to a breaking point. It is my view as a whole, and I just think everyone as a whole is doing best in a place that is not ideal. We can learn much from what we've now been able to do over the last 15 months in doing remote stuff, but I think there's still much to be done when we can go in certain circumstances back to court, or hybrid locations, solicitors' offices, etc., will be the solution going forward. Thank you for briefly listening. I know it's possibly, some people might say, a bit of a ramble through some views of my own and the challenges I've personally encountered in my views on certain matters. But let's see if there's any questions people have. I think I can see there may not any yet. Lots of congratulations to Luke. If anyone's got any questions,
there are a few questions. James, that wasn't a ramble at all. That was really, it was really interesting, and again, it brings a different perspective in terms of how, practically people are dealing with the situation that we're faced with. That in mind, I'm looking at the questions, and perhaps if I can throw this first question to James and Kirsty, because as practitioners, obviously we are representing people, but we've got an anonymous attendee, but also somebody in the chat had asked this earlier on, about people representing themselves in these situations, on going to court, representing yourself on an injunction. And the question says, would the court accept the request of a non-molestation order from the victim? And would the court believe the victim's statement too? Obviously, I mean, it's a situation, sadly, that not everyone has representation and has the fantastic representation that Rachel had. So I don't know if I can throw that out to Kirsty and James first, and then perhaps Luke and Rachel can deal with the second question and an additional one.
Well, I think the obvious caveat is it depends. Some clients are going to be more able than others to do that. And I think my concern would be, have they been able to capture all the salient points in any statement that they put together? They may well be able to tell a story of what's happened. But like the many examples we saw at the beginning of lockdown, not happening so much now, thankfully, where even with a solicitor preparing a statement that we believe has merits for ex parte, and a client preparing their own paperwork puts their story, they're in immediate fear. It's a subjective test, as we know legally, but then they don't get the ex parte order. Where's the support and advice that goes with it? So yes, they could probably do it, but I do think legal advice would help for most, certainly to navigate through the ever-changing system.
And as I don't have much to add to what Chris was saying, but my view, I think the difficulty I would say I've heard people have is trying to get solicitors who have the ability to assist as well, not because there are not for so much work at the moment, it is the difficulty. The judges will believe the story if you do it yourself. It is having the objectivity, I think, is always the benefit of trying to have someone like a solicitor or someone even if it's a legal centre to help, because they can just take that little step back and go, okay, let's make sure it's easily and quickly digestible, because that is the key in most of this, is at the very beginning, as a judge will see it. If they end up with a massive long statement with the relevant part at the very end, sometimes will get lost in it. But yeah, there's nothing stopping, and I wouldn't discourage anyone doing it themselves, but I think to now qualify for I think legal aid reasons, I think hopefully Kirsty knows better than I do, but if you can get some of the little bit of evidence, there are people who are able to support you, and I would advise that more than going alone in those circumstances.
Thank you, James. Thank you, Kirsty. Luke, if I can throw this one your way. Actually, there are two questions, and they somewhat overlap. Got a question here from Amanda Milmore. Given the fairly infrequent use of DVPNs and DVPOs, acknowledging the ridiculous 28-day limit on the latter by the police to date, do you think we are going to see more use of DAPNs or DAPOs? My concern is that we are still relying upon the police to start the ball rolling. And the crossover, Natalie Arnold's question is it expected that DAPOs will be police-led rather than parties applying themselves with legal aid funding? So I don't know, if you can deal with those, Luke.
So with the first question, I see the point, and it's a really good point, because obviously with the DAPNs, obviously that's the police job to issue a DAPN. Nobody else can. But in terms of the DAPO, that's the court's role. And so obviously one of the ways you get a DAPO or get the court to consider a DAPO is by getting the DAPN first. And then I did say there's an obligation for that person to be brought before the court and then to consider the DAPO. But there are other ways to get a DAPO. It doesn't have to be just police getting it, making a DAPN. You can apply, or the person can apply for a DAPO, or police can apply directly for a DAPO. So I guess the question is if we leave it to the police, if we take away the other ways you can apply for a DAPO, such as making it yourself or persons appointed by the Secretary of State, if you take those away and you get a situation where you would want the police to make that application for you, I guess it's the question, are they going to actually do that? And I'm not entirely sure if they will. I mean, they can make a DAPN if they have reasonable grounds to, but a DAPO, that's not their role, although they can apply for it on your behalf. But again, is it a duty to apply for it on your behalf? Which it's not a duty, which would have been a good introduction, because at least we put some duty on the police to say, okay, this has happened, and say they have to make this application on your behalf. But that's not something we see within the Act. So really, I'm not entirely sure. I think we're not just waiting for the police to get the ball rolling. As I said, there are various people who can apply for it on that person's behalf. And so, yeah, I hope that answers the two questions, actually.
That does. Thank you so much, Luke. There's another question here from Ben Major. But Ben, before I come to you, if I may, come to Rachel and ask her, as we're talking about the police, Rachel, if you can sort of fairly succinctly say, in terms of your dealings with the police, what was the most, perhaps, the one most significant difficulty that you had dealing with the police, when you were coming out of the trauma of the abuse and, seeking some sort of justice and redress? What were perhaps the single most difficulty you had with the police?
The police aren't trained to deal with domestic abuse. Officers do not know what post-traumatic stress is. I was dealing with non-moles and having post-traumatic stress, and they were accusing me of being a cocaine user. I wasn't able to give statements, even though there was medical records on there from top doctors saying she cannot give statements, and the reasons why. They were being ignored. So every time they come out, I had to go through it all, what I've just been through. Even just from that today, I've had to take a diazepam to stop me having a post-traumatic fit. They were even unlocking my vehicle without my keys. It has been awful, and they haven't been helpful. I think the DV, whatever order that they give you for so many days, it's for what my skill from it is with all of this. I think they are supposed to do that for you, to put immediate protection in place while you can even get yourself round to what's going on. And then I think that's when a solicitor comes in and then can talk to you and get you a proper non-mol. I think that is what they do. And it is really useful because that's what I needed. Like, I had no break. The minute I could talk, I had to go through the non-mol with Jazz. I think it's for that order to be put in so that he would have broke it, he would have been arrested, and then I think it gives the solicitor time then to go through that with the client and have a breathing space to get it done properly, which I think is really needed. And I didn't find out there's actually another order that's just come out. I'm not sure, I think it's a O something order. And that's for extreme cases like mine where the police can actually just remove him from you permanently until they do a full investigation. And you don't have to talk about it at all. I only found that out because we were disgusted the way it was being handled, and they told me. So there's loads of things that need changing, but I think it's important for the solicitor to get the non-mol, 100%. The police will not help you. They're not trained to help you. They do not. There was at one point when loads of officers said you need to complain, and I had the sergeant ring me up and said, do you think you're special? And I was just asking for a trained domestic officer to come out and deal with the statements, and not someone that doesn't actually understand what's going on. I mean, even now, I am still proving I'm not mental. He's in remand, and I've got people coming at the front and back property. They didn't believe me. I had to go out in the dark when my children were asleep on the phone to an officer saying, it's taking you ages. And there were 3 men in my garden. I mean, even now I'm proving it. It's just diabolical. The whole police service needs retraining. They do. The officer didn't even know, the sergeant, what post-traumatic stress was. I was having to explain it to him and why I couldn't give statements. And then you get a solicitor, Jazz, fully well knowing every single rule, what not to say to me, what will trigger me, knowing more than a trained police force. And that's what you're dealing with. The police are not going to help you at all.
Rachel, thank you so much. And those of us of a certain age who have been knocking around more years than we care to remember, hearing you say that is particularly saddening, because I know when I started out back in the 90s, started practicing, we were being told then the police were being trained, that they were understanding now that things were not just domestics, they were treating it seriously. And it's, sad to see that, what you're saying now, Rachel, unfortunately, I was hearing from clients, back in 1992, they have got a very, very long way to go still.
Yeah, I mean, you've got the solicitors knowing what these non-mole breaks are, knowing that they've broken them, and they're fighting with police force to go and arrest them and do something about it. I mean, I just don't get that. The rules that are set out are their game fields. I mean, every single rule that has been set out is something that they'd love to break. It does not make sense. There needs to be stricter rules. I mean, this person has broke his non-mole a record amount of time, and he's still allowed to do it. I mean, he's in remand now, dealing with 4 non-mole breaks, and they're only charging him for 1 in a Newton hearing, because he's that manipulative. They don't know who is doing it, if it's me or him. And I'm still fighting that now.
Yeah, which takes us quite nicely then onto the question from Ben Major. And I wonder if I can pose this to James and Luke, and then Kirsty, I have one more for you at the end here. Ben says this: do you believe there is merit or practicality in introducing a system within non-molestation order proceedings akin to the credit system in criminal proceedings for early guilty pleas, whereby a respondent is only subject to a non-mol order for 12 months if no findings are made, and the order is extended for a number of years or indefinitely if, as a fact, they find they are found to be an abuser when evidence is put to the test. So interesting, sort of making the analogy with the criminal system there. What do you think, James and Luke?
I think my view, and Luke can correct me if I'm wrong, because he appears to read the legislation and he's read it more than I have. But I think the fact it would be an interesting situation over the next, say, probably 12 to 24 months. Because the fact is, a judge who is hearing a non-mol application, from my understanding, can make the new orders if he feels, or DNPO could be made in non-mol proceedings at the end. Because if I would assume you persuaded a judge to go, look, actually, yes, the law says non-mol should only be made for 12 months, but look how bad this person has been. I think that is where you won't get indefinite non-mols, you won't get 5-year non-mols. I just think what you'll end up having is a judge making a DAPO instead of a non-mol. And the question will then be, what's the purpose of having the two symbols? I don't know. And in respect of it, there should be credit. My view is that if they're required, they should be required. And I think the only reason they aren't for longer periods than 12 months at the moment is because it's not encouraged. By listening to what Rachel's story I bring home is the effectiveness is very much down to the police having them in the first place. So that's just a bit of an observation. But I just think, I think generally a DAPO may actually at one point replace non-mols, because I can't see the purpose of having two very similar things and one can be made for longer than the other. But I don't know if Luke agrees or has any other comments to that. Luke, you're on mute. The typical remote hearing problem.
Jeez. Yeah, just to touch upon quickly what Rachel said, and I'll come to that question. The issue about non-mols, I think with the police, you see, with the non-molestation, it's a bit unclear as to when a police should arrest a person, if they have suspicion of breaching it, or if they have breached it. It's a bit unclear what it needs to be. But I guess with the DAPO, I guess you need to have reasonable grounds for breaching it, and I would hope that's a lesser standard to reach, to give that police officer grounds to arrest the person. So yeah, and in terms of the credit, I don't think they should introduce a credit system, because what that does is it just allows people to abuse the system, where they say, okay, I agree to it. It's similar to undertakings, where you get parties who just take undertakings, no findings made, and just get it out of the way, because they know after a certain amount of time, 12 months, there's nothing enforced to protect the person who you're trying to abuse. And so I don't think there should be a credit system at all. I think if a person is suspected to be an abuser and abusing somebody, based on that abuse and based on all the circumstances and what the court believes the amount in terms of how long that order should be in place, that's how long the order should be being put in place for, not if a person accepts what they've done from the beginning of the proceedings. I think that's the wrong way to look at it. I think it all depends on the actual circumstance of the case. So I hope that answers the question from my side.
Thank you very much, Luke. If people can hang on, say if we can go on until perhaps another 10 minutes or so, because I've got about 4 more questions. I would like, if possible, to get through everyone's questions that you've been so kind as to send in. Kirsty, if you could perhaps like to consider this one. It's from an anonymous attendee, but in light of concerns about remote hearings and ensuring safety / confidentiality of survivors within sensitive family proceedings, and in brackets, and with the new definition of domestic abuse in the bill, what are your thoughts on the omission of technological abuse within the definition? The bill is described as future-proofed so as to preempt types of abuse not explicitly included. But does this go far enough, given the lifeline and/or risk that technology can be for many survivors?
Thank you. Well, that's a very good point. Does it go far enough? No, I don't think it does. I mean, I think that's why we need to keep having these webinars and discussions to keep these discussions going, because it's far from perfect. What I would say around abuse via technology is you could bring that in under some of the other abuse definitions, harassment, intimidation. There'll be a way to bring it in. For many years, I've exhibited abusive emails or abusive messages, so it can be brought in, but it's quite right. I think that still needs to be understanding and better definitions to help them when you're in the courtroom trying to convince a judge that that is abuse on its own. So good point.
Thank you, Kirsty.
Alison, can I just chip in slightly onto that? I agree completely with Kirsty, is that it's educating people that these sort of abuses actually exist. One, I think, talks like financial abuse, financial control, and things like that. It's like people are blinkered. We all very much probably want to sit around here, we would be able to spot domestic abuse, but understand everything. And I think the reality is it's just educating people and bringing things up, saying it's issues, highlighting the problems and having discussions. And people will then see things. And actually it's having people who are willing to put the cases forward to say, just look at this as the control. And it is being brave and actually saying, look, this does exist. Look, Judge, you need to look at it this way, or people, you need to look at that, and it's educating. And I think that kind of will help make the bill more future-proof in the sense of people actually bringing up issues and have you thought about this? Have you thought about that? And I think in this day and age of remote doorbells, those good old-fashioned ring doorbells everyone thinks are useful, but look about it the other way. You might think, oh, your neighbours have that installed. Oh, because they like to get their parcels. It might be very other reasons that they know when people are leaving their house or people are entering their house, and it's all on their phone. So it's things like that. It's just keeping your eyes open, I think, is the key issue, and educating and having seminars.
Thank you very much, James. I'm going to go round and some quick, pithy answers, please. James, as you were just speaking, would you like to deal with this one from Jasbir Randy, who says, for the legal speakers, are you able to assist us with the legal basis on which the court is entitled to accept a non-molestation order being made without findings being made and no admission from a respondent? I cannot find anything in the legal text about this. Thank you.
So looking at the question, I've just found it in the set of the position in respect of that is, I assume what they're talking about. I go to court, or Kirsty takes me to court. She asks the judge for a non-mol against me. I go to the judge, fine, I'll agree to it. I'm not going to accept anything, and so forth. and therefore it's basically a consent order, and I'm consenting that I will agree to the application in order Kirsty has asked, and it happens all the time. To find the exact basis, the legal basis, I can't, I don't know the answer off the top of my head, but we all, like numerous occasions, you go with no findings on the basis, and the reason people do it is that there will probably be children proceedings about to happen, and you don't want findings at the start of those children proceedings. That's my pithy answer.
Thank you.
Can I just quickly add that
Yeah,
Mr. Jasbir Randy, that is the Jazz that was Rachel's solicitor. So well done, Jazz. It is. Yeah.
Congratulations, Jazz. You're doing the profession proud. That's fantastic work. And thank you, Jazz. Kirsty, can I throw a couple at you? A few questions. One here from Ron. Very much comes out of what Rachel was saying about her abuser and, you know, repeatedly breaching orders again and again and again. How do you deal, as a lawyer, how do you deal with someone like Rachel's abuser who sees breaching orders as another challenge?
Yeah, I was just checking I was on mute. It is an issue, and like you've heard, that we've tried to assist clients by challenging the police with them in terms of what the law is there to do once we're outside the family court. But there's also committal proceedings that you can consider as well if it's got the appropriate wording on the order. So it depends, but there are certainly things we can do. For a short answer, you said short.
Yep. Another short answer then, Kirsty, and this is from Cyrus Mansouri. In my experience, the judges are getting increasingly hard-nosed when faced with ex-parte applications.
Yeah.
I noticed this as the FLA effects of COVID increased over the course of 2020.
Yeah.
Have you noticed any change in the approach of the judiciary?
Yes, sadly, and a case springs to mind very recently, in fact, where a client was ineligible for legal aid, but I've assisted her pro bono, and I'm doing another shout out to Jazz there, because I had 2 hearings I was doing that day myself anyway, so he covered the hearing pro bono for me. It was a case that she had got help from the local CAB office to actually prepare the application and statement. The details of the abuse were absolutely horrific. The sexual abuse was absolutely mind-blowing. It was an ex parte order every day of the week. She made that application herself. The statement was sound. There were some few missing paragraphs that you would normally draw the judge's attention to, the reason for urgency, justification, etc. But the detail was in there if they'd read all the statement. So she'd issued the application herself. It was listed on notice. Then she came to us for help with that on notice hearing. So it was very difficult because it hadn't been dealt with the way in which we would have thought. But at the on notice hearing, judge refused to make the order. So there are many instances that we are seeing where, yes, judges are being reluctant to grant ex parte orders. And I've seen some courts, they've almost got a ranking approach to it. How serious is it? Is the client black or blue? What type of abuse is it? Because they're so overwhelmed with the number. Not that they don't want to help, they are just absolutely swamped, and so they've been forced to make some very difficult decisions. So yes, I have seen some issues.
Thank you. Before I come to you, Luke, with a few more questions about the Act, James, because it chimes in with your presentation and about the practicalities and our experiences, have you noticed the sort of hardening of the judiciary?
Yes, but I also think it possibly was pre-COVID, and COVID's made it worse. In reality, on the basis of the changes into legal aid rules, when they said you'd only get legal aid if you're a victim of domestic violence, and I think some people have gone, actually, that is the reason they're only applying for non-law, is to get the legal aid for their private law children application. So I think COVID's made it worse.
Thanks, James. I want to leave the last word with Rachel, but Rachel, before I come back to you, Luke, question here from Dorota. I would just like to clarify the situation of migrant women in Domestic Abuse Act. Linking police intervention with immigration checks must be adding to anxiety, especially if there is a language issue. And Dorota goes on to say, I'm doing a PhD on barriers to reporting domestic abuse by Polish women, and it's been really helpful discussion. So I'm glad you found that useful, Dorota. But going back to your specific question, Luke, can you have any thoughts on that? Luke,
Muted again.
You're muted again.
Apologies. It's something that I do in court hearings all the time. But I think that's an interesting point. So obviously, if police are involved, then there's a potential for immigration checks to also. And I think that's a good point. And I don't think the Act actually, well, it's not going to cater for that, is it? Because it just wouldn't. And so I think that's a real gap, a loophole, where a lot of migrant women are possibly not going to say anything about the abuse because of that particular reason. I think that's a good point. So thanks for bringing that to my attention. The Act doesn't deal with that, and it wouldn't deal with that. So that's something that's a good point. So thank you.
And Luke, in terms of sort of looking at a critique of the Act and the earlier question about whether it went far enough and the technological aspects and how that can be missed, and are there any other areas, any gaps, any lacunas in the Act that you can see from the research and work you've done for the presentation today?
I think for me, I think there are a few gaps, but I think the most important one is really it's sort of how is this going to work alongside the non-molestation order provisions. That's the real it's a gap. It's something that's not really clear. And as I said, the government has said that they will issue statutory guidance, and so we would hope that, well, any questions or about the Act and any loopholes that we believe there are, we would hope that the guidance would address that. But yeah, I think I'm sure there are loads of loopholes in the Act.
Thank you, Luke. I'm looking at the time, and I think we've gone through most, if not all, of the questions, in fact, now. So I'm going to bring proceedings to a close. But before I do, Rachel, I wanted to bring you back in. Firstly, I don't know whether you can see the chat, but there have been, it's been full of messages of support for you, people thanking you for your bravery and courage in speaking today. People have described you, as Luke did, as an inspiration, and that they're wishing you also, going forward, strength in the future for you and your children moving forward from this, and to see yourself very much as a survivor, not as a victim. And I would, on behalf of the panel, completely echo those sentiments. It's been a real pleasure listening to you, and I'm sure going through that trauma, your abuser thought of himself as a strong one and you as the weak person to be terrorized and abused and coerced, and you've proved him wrong. Your strength as a woman, as a mother, is incredible. So you need to be very proud of yourself and proud for what you've done for yourself and your children. So with that little eulogy being said, is there anything, I'd like to give you the final word, Rachel. Is there anything you'd like to say before we close the meeting?
Yeah, I'd like to say thank you for all the help from Jazz and his team. I definitely wouldn't have been able to go as far as I am without them. And they've given me the strength to carry on. I am going to change the law. When he's got his sentence, I am going to put in changes, whether it falls or whether it doesn't, I am, because he's not doing that to me, and nothing good coming out of it. There needs to be strict guidelines when these people break these non-moles. You know, all the hard work getting them and all the emotional impact on the victim and the solicitors, and they just get away with it. It should be set rules, how many times to break it, and exactly what punishment that they should be getting, because they do not get punished properly. It's just, I feel like sometimes all the hard work from them and getting them from the solicitors and team, what has that actually done, or what has that actually done to protect us? I mean, even with the officer here, on the first week he had it, you know, this person has got no regard for the law. She's got a non-mole, but this is no physical protection. The only protection is relying on the prosecution to protect them, and they're not protecting victims. I mean, getting a non-mole is great, but the CPS are not acting on them. And no wonder the police don't want to arrest people. And mine, luckily, has got arrested on most of them. And they let them walk out. It's just, you know, there's just failings throughout with this. I can understand why the police don't want to arrest them, because they know they're going to walk out. It needs changing.
Thank you, Rachel.
It really does.
Thank you so much.
Thank you.
No, thank you. Before I do end the webinar, just a few people to thank. But before I even do that, just looking through the chat and the Q&A, can I just mention that somebody had asked for the details of Rachel's solicitor, and now that we know who it is, I think it was somebody, Mrs. Shah, had put in the chat that she wanted to know who Rachel's solicitor was. So now you know, it's Jasbir Randy.
Yeah, National Legal Service, Birmingham office.
So there you are, Mrs. Shah. There is also, I think I should mention, somebody, Vicky O'Neill, very kindly put in the chat, I don't know if everyone's seen it, but she works as part of the FLOWS team, which is finding legal options for women survivors. And their Court Nav tool was opened up to everybody in E&W at the start of lockdown. This helps survivors apply for non-molestation orders, and over 9,000 applications were checked by a solicitor during the first year, signposted to LA solicitors where eligible, and advice given to litigants in person. So that's a really good resource to be mindful of. So, and Abigail has also, Abigail Holt, our very own Abigail Holt, has also mentioned there is a national referral mechanism to deal with issues relating to migrants suffering abuse and violence when it's part of their migration experience. And in Abigail's experience, that it seems to be used very rarely. How widespread is the knowledge of the NMR ? So, Dorotho, I hope that's a further piece of information that may be of assistance. Can I just then thank everyone on the panel for yet another wonderful seminar, some really interesting presentations. And I know that we had some technological difficulties with Luke's slides at the beginning. Some people couldn't see them. Fear not, the slides will be available to all attendees. So all of Luke's hard work producing those slides will be available to everyone. Thank you to our speakers. Thank you to all our attendees as well. And two other individuals who need special thanks. Well, three actually, but firstly, Abigail Holt. Abigail, who is a senior member of the civil team here at Garden Court, is really the leading light and motivator behind these series of webinars. So we thank her for her coordination and organisation for the whole series and being very much the motor force behind us doing the series in the first place. And secondly, to Anne Osborne, a senior member of the family team. Anne in particular has been instrumental in putting together and coordinating today's webinar, because obviously it comes very much from a family law perspective. So I thank Anne and I thank Abigail. And finally, Amy. Amy Hughes, our wonderful marketing and IT person, who has helped us with all the problems. She resolved the problems with the slides. And so thank you very much, Amy, for everything that you've done. And there's Anne for everyone to see as well. So thank you. And Abigail is here, but we can't see her, but thank you again, Abigail. And I think that on that note, that's the end of the webinar. We'll see you again for the next in the series.